I've been in Bermuda for, about 12 years. Recently moved back to the UK. Past couple of years, I got quite involved in what was going on in Bermuda in terms of attempts to do a little bit of what the previous talker was saying about, which was legalization, and specifically of cannabis. And in the end, what blocked it was the UK, because the UK retains a veto over Bermuda's laws. And so at the moment, it's been stymied at the moment, and I think there may still be things going on there. But part of that is I have a big focus as well in terms of constitutional rights, human rights in my practice, and so I started looking at this as well. Bermuda's Misuse of Drugs Act is pretty much the same as the UK's, and the regulations is very similar based on it, basically. And so I started looking into what's the situation here in terms of how could human rights laws that we have as well be used potentially to challenge some of the aspects of the Misuse of Drugs Act, and particularly looking at maybe plant medicines and personal possession cultivation. So the most basic of kind of personal rights, not talking about commercial trade or anything, but just is there scope to use human rights laws to allow some kind of exemption for personal cultivation, possession of cannabis, mushrooms, that type of thing. And so I started looking into it, and it's quite interesting. And I see some scope here, which I think could be a lot of interest for people who are either found and being prosecuted for those types of offences, for NGOs or advocates who are trying to change the law, looking for ways to involve the courts in that, or just people in general, people in the community who have an interest, who might be interested in seeing what can be done in this area. I've been involved already with some cases before the courts here, looking at what scope there is. And so I thought I'd give you just a quick overview of how that can go and what could be done. I think the UK Human Rights Act, which came into force, it was well over 2 decades ago now, in the late 90s. And there were some initial attempts at this back in the early 2000s. There was a guy who the police raided his house. He'd had an argument with his partner, and she reported him to the police. And when they raided his house, he was unfortunate. They found 14 grams of cannabis and a cannabis plant that he'd been growing. It was dead already, but that was enough to do for cultivation. They found a dead plant in his house. And this is back in 2002. And he tried to raise a defense based on the rights of private life under the Human Rights Act, that his right to private life meant that he should have a defense for these particular activities of merely possessing cannabis and growing cannabis. And he didn't get too far. The Court of Appeal was extremely dismissive, saying that a right to private life did not include a right to what they call self-intoxication, and basically dismissed the whole thing. So that doesn't come anywhere near your right to private life as your right to get intoxicated. So there was that case, and there were some other ones as well in the early 2000s, and it basically put the lid on it. The courts were sending clear messages. They were not interested in any kind of private life arguments in terms of being able to use cannabis or other plant medicines. There's a case for ayahuasca as well. That's one of the Santa Daime churches. That was unsuccessful. Rastafarians as well use cannabis for religious purposes as well. And the courts made it quite clear we're not interested. But the thing about human rights law, it's not like contract law or property law where you have a case from 100 years ago and it's still that's still what it is today. It's when you're looking at human rights, it's a fast-moving area, and there's a lot of scope for change depending on changing attitudes, notions, views, and just what's going on in the wider world as well. And so, looking into this, I believe there is scope for the courts to revisit it. The case I mentioned, the Morgan case, that's specifically about the right to intoxication, so how they phrased it. But there's been other cases since that I think can point to a different approach. There's a couple of these I'll mention. It's two very different groups of people: fox hunters and people who are detained in high security psychiatric institutions who want to smoke just tobacco. They both had cases before the courts in the mid-2000s. So 2007, UK had a smoking ban. Mental health units were given an extra year before that went into effect. So July 2008, inmates of mental health institutions were told, no more smoking, not allowed to smoke anymore. And a handful of smokers took their situation to court, and the Court of Appeal heard the case. It doesn't have a very snappy name. It's just called the case of NV, Secretary of State for Health. The Court of Appeal was split. Lord Justice Keane was on the side of smokers. He said, it's a pastime greatly valued. One knows of writers and journalists who come up right without smoking, while others seem to obtain great pleasure from smoking after eating or other activities. So a euphemistic comment from Lord Justice Keane. But sadly for the smokers, the majority found the case did not engage the rights of private life, because they said that basically these were not people in their own home, living their life in their own home in private. They were inmates of an institution. And they made a key distinction there between regulating somebody's behavior in a psychiatric institution and somebody's behavior in their own home. And this is where the fox hunters come in. A couple of years before, the government was banning fox hunting as well. And it went all the way to the House of Lords at that time. The House of Lords, not the UK Supreme Court. And the House of Lords heard that case on the ban on fox hunting. And again, that case was unsuccessful. The House of Lords dismissed the challenge to that ban, largely because fox hunting is a noisy public spectacle, not an activity you quietly carry out in your own home. And the Court of Appeal then in the smoking case later, they alluded to that case. So they obviously the House of Lords case is the big important one, and then it's followed by the Court of Appeal. And so they took that reasoning, and this is where even though the smokers of the mental health institution weren't successful, we do get an interesting glimmer here from the Court of Appeal that I think points the way to a different direction from that earlier case I mentioned of poor Mr. Morgan, where the police found his dead plants. And that's this. So the Court of Appeal in the N case, the smoking case, they said, Article 8, that's the right to private life. Article 8 seeks to prevent intrusion by the state into the physical and private space which the concept of home represents. For example, what one eats or drinks may not be important, but that the state should dictate what a person eats or drinks in the privacy of one's home would be regarded as deeply intrusive. And then went on to say, any intrusion within that inner circle of private life is offensive. It is the fact of intrusion into the home which offends, irrespective of the importance of the activity which an individual seeks to pursue within the home. So what's implied there from the Court of Appeal is that if the government had been trying to ban smoking within people's own homes, then Article 8, the right to private life, would have been in play. What the government was doing, the government was only seeking to ban smoking in public places, in restaurants, cafes, pubs, hospitals, mental health hospitals. They didn't stop people smoking at home, but they're suggesting that if that ban had been wholesale and covered people's own homes as well, then Article 8 would be in play. So that's suggesting that Article 8 is engaged with activities like smoking tobacco. And if smoking tobacco, why not other things that people like to smoke or consume? So this shows to me that it shows a principled departure from the earlier cases where the courts are saying, no, anything to do with this has got nothing to do with Article 8, nothing to do with the right to private life. We're seeing here in this in the N case from 2009 that actually it can be engaged. So I find that really intriguing. Now, that's not the end of the story. I mean, that's part one of a legal argument, that you've passed the hurdle of saying my private life is engaged. Then you move on to a second part of it, which is called an exercise in proportionality. So under the Human Rights Act, the starting point is that we all have certain rights, and one of them is the right to private life, right for that not to be interfered with. And then the government can interfere with these rights, provided it's reasonably justified in a democratic society. And then you have to explore a proportionality exercise of whether or not these prohibitions are justified. And that's why that's really where I feel the heart of these cases could go to, is that proportionality exercise. And again, this is an area where we have seen a lot of change in recent years, both in terms of the therapeutic uses of some of these substances, that's come a long way in terms of what's understood that they can do. And just in terms of social attitudes in general, we're seeing around the world so many countries are just completely ignoring the international conventions when it comes to cannabis. I mean, half of the states in the USA, you can buy cannabis openly. Canada, many countries around the Caribbean, South America. So the justification that there's an international convention here that means that these substances have to be prohibited in a particular way, that's kind of fallen by the wayside. And in terms of the more legal side of things, the judicial side of things, courts are also starting to take that approach as well. So there's a couple of key cases, recent cases that I identify here. One is from South Africa. There's a case, the name of the case is Prince from 2018. And that's a case that's been going on for many years with different stages. But what I see as the highlight of that case is really 2018, the South African Constitutional Court. They had little hesitation really in finding that the criminalisation of cultivation and possession of cannabis for personal use within the home, for that particular exemption, was basically an unjustifiable and invalid interference with somebody's right to privacy. So that's South Africa, where the courts made that ruling, which basically creates a constitutional, a human rights exemption for that particular activity or for those activities. And it's not just in South Africa. Another one is down in the Caribbean, St. Kitts and Nevis. And this is a case 2019. This was, it basically followed what happened in the South African case. The interesting thing about St. Kitts for the UK is that St. Kitts is one of the few places in the world where King Charles is still their head of state as well. You know, you've got like Australia, Canada, you've got a few Caribbean places, and St. Kitts is one of them. So their judges are appointed under authority of the king. It means it's essentially their judges, and it's called the Supreme Court of the Eastern Caribbean. It hears cases from all over that region, all these countries where they still have allegiance to the king. So that their judges deserve respect in our courts because it's basically a sister judiciary. They're appointed via the king's authority in the same way that the judges of our high courts, Court of Appeal, Supreme Court are as well. And I think actually in St. Kitts, I'm not sure. I think they may still have the Privy Council as their highest court. Certainly, some of those jurisdictions that go to the East Caribbean Supreme Court, their cases can end up in the Privy Council, which sits in London, and it's the same judge that sits on our Supreme Court. And so when St. Kitts, when their judges, in their regional court, are also come to that conclusion that the prohibition on personal cultivation and consumption of cannabis is an unreasonable interference, a disproportionate interference with your right to privacy, then again, that's something which I think the case we made in this country for our courts, that's something that's taken to be a very persuasive effect. So that's kind of the legal steps, the legal part of it. In terms of the legal consequences, if you're successful in those arguments, then what can it lead to? So in this country, it can lead to one of a number of different consequences. The first is that the Human Rights Act is quite a radical tool to reinterpret statutes. So even when a law has been passed, where it's quite clear that Parliament had no intention whatsoever that they were going to allow any kind of human rights exceptions or anything, the Human Rights Act at Section 3, it says that that if the judges can basically interpret other laws to bring them into line with the Human Rights Act, if it doesn't do too much damage or injury to that law itself. So there could be an argument that it wouldn't be doing injury to the very kind of the very purpose of the Misuse of Drugs Act to allow a personal exemption, an implied defense for personal cultivation, personal possession. That's one way that it could go. Another way is if the judge felt, well, no, that's just a step too far, I'm not willing to make that kind of interpretation, what you can do is you can ask a judge, well, that you might not be willing to intervene yourself, But if you're persuaded that this is a disproportionate interference with somebody's right to privacy, to be able to possess cannabis in their own home, not going out trading it, but just being able to have it in their own house, or other substances, then the judge can make what's called a declaration of incompatibility with the Human Rights Act. So a judge could declare that certain aspects of the Misuse of Drugs Act, or the regulations that come under it, are incompatible. That then basically forces it to be sent to the minister. The minister who's responsible has to pay attention and is basically invited to make what they call a remedial order to bring the law into compliance with the Human Rights Act. Now, so there's a bit of kind of wishy-washiness there, because potentially the minister can say, I'm doing no such thing. But the fact that the courts have said that creates some kind of expectation that this needs to be sorted out, because the courts would have said this, you're not in compliance with what you've said you're going to do in terms of the Human Rights Act. So there's a couple of things to be done there. And the other thing to be done is that in terms of the regulations that come under the Act, which govern who's allowed to cultivate, like, for example, that you can get cannabis on prescription, for example, in this country if you have particular diagnosed conditions. And so there are regulations to determine who is allowed to cultivate in order for the purpose of creating a commercial supply for that, and who is allowed to be prescribed and everything else. So you can also have you've got to have some kind of intervention by the courts into how those regulations operate. So there's quite a lot that can be done if the right case came before the courts, the right type of person who's not involved in any kind of black market activity, but is merely mind their own business in their own home. I do feel that the time is probably right to do this. There's a bit of threat. The current government wants to get rid of the Human Rights Act and replace it with what they call a British Bill of Rights, which would be a bit watered down. I don't see it as being that it would completely quash this type of action, but it might make it a little bit harder. But I still feel that even if they did get rid of the Human Rights Act and replace it with this other thing, that there would be options there for declarations of incompatibility. So that's a key aspect of it. I've got a couple of topics. So that's the first one, really, is the human rights aspects. I also wanted to talk about the UK hypocrisy at the moment in terms of implementing and abiding by these international conventions. And this is something which came to me particularly from my time in Bermuda and dealing with how these cannabis reforms were being looked at, where the UK basically just stonewalled it and said, no, we're vetoing this law. We're not going to allow this law to go forwards. It's not in compliance with our international obligations, so we can't do this. And the same thing happened down in BVI, British Virgin Islands, and other overseas territory, where they tried to pass a law back in 2020, which would have allowed essentially somebody to self-declare that they needed cannabis for therapeutic reasons. Like, instead of having to go to a doctor and get a prescription, which is the case in this country, which is extremely onerous, and especially if someone doesn't have the funds or to be able to go and get private consultations. So BVI said, okay, well, we're just going to let people self-declare to be able to possess and purchase small amounts of cannabis. And the UK, again, that law just disappeared into the back rooms of Whitehall, I guess, and never reappeared. But what is interesting is look at how the UK treats Jersey. So Jersey, one of the Crown dependencies, down in the English Channel, major offshore place, lots of business based there for the purposes of just having their office there so they can benefit from Jersey law. Now, Jersey, back in a couple of years ago, 2021, the Jersey Parliament or Assembly decided they wanted to get in on cannabis, and they wanted to amend their Proceeds of Crime Act. The previous talk was talking about organized crime. Proceeds of Crime Acts are designed to stop, so basically, if somebody is making money from illegal activities, then the state can basically come in and take it all. It gets forfeited. And that's the case whether the activities that you're engaged in are in that country or another country. So if somebody is in England, but they're involved in illegal activities or things that would be illegal in this country in another country, then that gets taken as well. So Jersey, they passed an exemption. The only exemption to their Proceeds of Crime law is that these offshore companies in Jersey, they can be involved in the cannabis trade as long as it's lawful in the country where the activities are occurring. Now that might not sound so bad. You think, well, okay, well, it's lawful in that country. Canada, so let's say Canada's got legal cannabis, and so a Jersey company based in Jersey for tax reasons or whatever reasons they want to be in Jersey, and then be involved in investing, financing, managing the cannabis business in Canada. But why is that a problem? Well, it's probably because the international conventions, the 1988 Convention against trafficking in narcotic drugs, it says that you shouldn't be doing that. You shouldn't be involved in commercial trade in your own jurisdiction, and you shouldn't be doing it in other jurisdictions if it would be contrary to the convention. So Canada's got legal cannabis, which is basically against the international conventions. You're not supposed to be doing that. Canada's doing it, and essentially what's happened is that the UK, Jersey's laws again have to go to Whitehall to be signed off on, and the Foreign Office has to say yes or no to their laws. So it's quite interesting to me that the UK government will stonewall any efforts to allow any kind of cannabis recreational use, whether it's in this country or in the overseas territories, but it's quite happy to allow it for the purposes of commercial elite investment. And that is I mean, it's major hypocrisy, I see. If the convention says that that commercial offense, it should be a commercial offense, it says I make a commercial offense if you're involved in the organization, management, or financing of activities contrary to this convention, then the UK, I say, must be in breach of the convention. And so what's the justification there? That it's okay as long as it's elites making money in offshore jurisdictions, but it's not okay for other reasons. So I believe the scope there. It's something which if you look this up online, if you're trying to research this, the only articles you find is articles by law firms saying, oh, look how good Jersey is now, come and set up your business here and do this. And maybe it's not such a bad thing from the point of view of being able to get involved in those kinds of industries. But from the point of view of the UK claiming on the one hand, say, oh, we care so much about the international conventions here, we need to abide by them. But on the other hand, basically allowing this type of thing to happen in Jersey, I think it points to something there which I feel is significant. The fact that the international conventions themselves are being flouted now around the world, I think really does call into question their validity. There is a requirement of international law that if countries are not abiding by treaties, it can lead to them no longer being of effect. Back in 2020, the president of the International Narcotics Control Board, which is the UN body which was set up to monitor implementation of the convention, he said there's a question as to whether those treaties are still fit for purpose himself. So there could be scope to argue that to abide by the UK can no longer put forward an argument that these treaties are what justifies its actions, because when you drill down on it doesn't really have any standing.